Welcome to our webinar today on local laws and open government laws. I'm Jeanette Stanziano, Director of Education and Training for your New York State Association of Counties. On behalf of the Honorable Martha Sauerbrei, NYSAC's President, and Stephen J. Aquario, NYSAC's Executive Director, and the NYSAC Board of Directors, I welcome you to county government and congratulate you on your election and/or appointment. NYSAC welcomes you as a member to our association, and NYSAC's mission is to represent, educate, advocate for, and serve New York's counties and the thousands of elected and appointed county officials who serve the public. As the voice of county leaders throughout New York State, NYSAC is steadfast in communicating the needs and recommendations of our county officials to state lawmakers. Local government is at the heart of New York State, and NYSAC is proud to represent the counties and their elected and appointed officials throughout New York. Please note that we have one more training next Thursday, February 3rd, that you can participate in, which will cover the role of the clerks of legislative boards and all of their duties. And also a second half will be on NYSAC programs, services, and education and training. Basically everything that NYSAC can offer you as a member. Please visit the NYSAC website at nysac.org/webinars for more details and to register. We hope that you find today's training thorough and insightful as you begin your commitment to county government. Just a couple of housekeeping announcements before we begin. We will be recording this webinar, as we do with all of our webinars, and we will be posting the webinar with a PDF of the slide deck on NYSAC's website by about noon today. To find this, just go to nysac.org/webinars and just look under today's date, and you will see a link to the recording and to the PDF of the slides. We also want to encourage you to feel free to submit questions throughout the program. To do so, just refer to your dashboard today on your screen, and you will find a questions tab. Click on it at any time during the program and type in your question to submit it. We will get to the questions at the end of the program during a brief Q&A session with both speakers. Now I'd like to introduce our speakers for today. Patrick Cummings is NYSAC's in-house counsel. Patrick is counsel for the New York State Association of Counties, and in this capacity, he tracks pending legislation and advocates to help county government run more efficiently. Patrick also provides support when requested to county attorneys regarding laws, policies, and cases that impact counties. Prior to joining NYSAC in 2011, Patrick was an assistant county attorney for Schenectady County. Pat is an alum of Clarkson University for his undergraduate studies and earned his JD from Albany Law School. Today, we also have in the second presentation of our program today, Shoshana Bewley, who is the Executive Director of the New York State Committee on Open Government. Shoshana was appointed the Executive Director of the New York Committee on Open Government, an independent governmental program housed within the New York State Department of State, in January of 2020. In that role, Ms. Bewley is responsible for the oversight of her staff and the operations of the committee, which provides legal advice and guidance to the government, public, and news media on New York's freedom of information, open meetings, and personal privacy protection laws. On a yearly basis, Ms. Bewley and her staff respond to thousands of inquiries. They prepare hundreds of written legal advisory opinions and provide open government laws training to dozens of interested groups and make recommendations to improve open government laws in an annual report to the governor and the state legislature. Ms. Bewley previously served as the General Counsel and Chief Legal Officer at the New York State Office of Information Technology Services, where she oversaw the agency's legal department, providing advice and guidance on legal and regulatory compliance, information security and data breach response, cybersecurity incident management, legal and technical e-discovery compliance for the New York State executive agencies, New York State IT policy, and strategy alignment. Ms. Bewley came to public service in 2007 after more than 10 years of private legal practice and is a member of the New York, Connecticut, and California State Bars, and is a graduate of Vassar College and the University of Connecticut School of Law. Thank you so much, Pat and Shoshana, for agreeing to participate today. Our officials in the county system will benefit greatly from your expertise. Now I'd like to turn the program over to Pat Cummings to start his presentation for today. Pat.
Thanks a lot, Jeanette. And yeah, let me just echo what Jeanette said. I thank all of you for joining us today, especially for newly electeds. Happy to talk to you about local laws and what exactly those are, what the powers are, how the authority is granted to you as local officials to pass local laws, and what the restrictions and the where you can go, what the ability you have to use those. It's important for you as local officials to know that, and even the process on how it happens within your county. I also want to give you my cell phone number right off the bat, because I think what happens is with these trainings, we're trying to educate you on these, but there's never, we're going to have time for questions at the end. There's always going to be questions that come up, and I'm here and happy to help with answer those. And if we can't do it now, as members, this is what we do for you to help guide you and your county through the questions that come up every day with your job. So my cell phone is 518-698-6682. That's 518-698-6682. Call me anytime about this or any other county issues, and I'll try to work with you or through your county attorney to help guide you. Next. There's going to be some takeaways from this presentation, but ultimately what I really want you to know, and I'm going to go through this presentation set up for more like an hour with the slides. I'm going to go through pretty fast the beginning, the authority of where it comes and the power that you have, why you have the power to pass a local law. But I just also want you to understand where that comes from, so that if you're ever challenged on that, you know that it's solid, that you do have that ability. I really want to make sure we understand the structural components of a local law when we leave this, because by failing to put in certain structural components, that can cause your local law to become void. The procedural steps are also very important for you to understand and know, and that also is one of those things that these are by law, so you have to follow these certain steps, or it's void or voidable to local law. Then I'm going to give you a few examples of things that you can do, because we're going to talk about the 50,000-foot view of what you can and can't do with local laws. It's always easier to work with examples. And I'll talk to you about what has happened in the past even 10 years with local laws, so you can have a better understanding of what you can do, and then the restrictions of what you can't do. We'll talk about that with some examples as well. And speaking of examples, I do want to point out that there is a great resource, and we'll also talk about where you need to file these and the procedural steps. But the Department of State, New York's Department of State, has a website of all local laws. You need to, and we'll talk about this later, you do need to file your local laws to make them official and to make them effective within the Department of State. They have done a really good job of posting all of those. And you can search for on their website. You can search for every local law across the state based on year, based on subject matter, based on county passed, and this helps for a number of reasons. Again, to figure out what you can and can't do. Also, part of what NYSAC does is this is a good example. What NYSAC does is you can feel like you're on an island a little bit sometimes as county government, and this helps you look around and say, well, you know what, the issues we're going through locally are probably the same in 3 counties over, or even across the state. How did they handle this? Did they do something with a local law? And you can find examples from that website in the Department of State to see, do I need to reinvent the wheel, or can I find it here? So I think that's an important thing to know. Next. Under municipal home rule law, this is a state law. I just put the definition of what exactly a local law is. They define it by state law. you know, in a nutshell, a local law is a law. That we call it local because it's within the boundaries. The only place that it has its power is within the boundaries of the body that it's passed, but it has the effect and power of any state law, any federal law. It is the law of the land until and the interesting thing about local laws is it's last in time. You pass a local law, it is good until either a court says it's not, or until you pass another local law related that supersedes that. This is different, and I want people to understand this is different than a resolution. A resolution, there's typically, they can last a while too, but there's a resolution can have a power of law as well, but those are typically meant to be shorter in time. Your local law is meant to be forever, again, until another body or your body says it's not, or a court says it's not. A good example of this is, the difference between, let's say you pass the town passes a local law for a speed limit on a certain road. That speed limit's on that road until, again, that body says it's not. Your budgets are typically passed by resolution. Resolution, it's a 1 year. It's a 1 year action. It's a smaller in time action. The procedurally, and I won't get into resolutions. I want to say with local laws, it's a little looser. It's not as much. It's not as the steps to need to pass a resolution are a little less strenuous than your local laws. But that's the basic difference. Next. So we're going to talk quickly about the authority and where you're granted your power for local laws. It is granted within the New York State Constitution, and it is it's important that's in the state constitution because that means it's unlikely going to be taken away from you, that power. Well, we'll talk about in a little bit. The state can define the scope of that power a little further with state law, but the actual power and strength that you have comes from Article 9 of the state constitution, allowing you to have the ability to pass local laws within your county. Next. So again, this is under Article 9 of the state constitution that protects this, and it gives local governments all the ability to pass local laws. And we notice that it's counties, cities, towns, and villages that gives these local governments the power to pass these. It's also important to note it's not school districts, it's not special districts like fire departments, right? They can pass their own budgets, and we talked about more like resolutions. However, they cannot pass laws. They cannot. They're not. It's counties that are passing laws that can be everything from that require civil penalties to, I'm going to talk about a little bit, to even criminal penalties. It's counties, cities, towns, and villages, not school districts, not special districts, and that is by constitutional powers. Next. Okay, so this is also within the Constitution, protecting there's 10 areas that it says that really what a county can do and what the state can't tell us what we can't do. And one real big takeaway I want to point out here is one of the biggest home rule powers you'll have, that again the state more or less needs to stay out of, is how the transaction of your local government's business and how you conduct your business. So this is in a way why you see so many counties have different ways they organize. Some counties have board of supervisors, some have legislatures, some have county executives, some don't. Some have county admins, some don't. How you organize and structure your county is protected by the state constitution, and based on the needs of your people and how to give those services you need, or really is going to be how you form your county and operate. Now, we have a lot of similar functions, and that's because under state law, and even a little bit in the Constitution, we're required to provide certain services, right? By state law, we need to have a DSS to help with Medicaid services. We need to provide a public defender's office, right? Every one of your counties does that, or through your 18B, right? You provide indigent defense in some manner. You all have now sheriff, for example. You all have sheriff. That's a constitutional requirement. So you're going to have some of the same framework, but indigent defense, right? I just mentioned that you could hire outside counsel, something called an 18B. You can have private attorneys do that. You could also have in-house counsel, something called a public defender. How you structure that is up to you. You pass local laws to do that. You want a county administrator, not an elected official, you pass a local law and adopt and get a county administrator within your county. That is not something the state can really interfere with. That's your within certain restrictions. That is up to you and how you do that. Next. Local that was I do want to talk about police power too, real quick. So it mentions a lot of different things, so one of the big things, and if this says this is a future slide, we'll just pass it, but I'll just get to it right now because I just saw police power. So county, how you form the three, in my view, the three big things that you can do with local law is your county organization, your police power. And so what does that mean? So it's under home rule that's your policing power is everything from stopping public nuisances, and that can be liberally construed. Your public nuisances can be anything from air pollution, noise violations. You're preserving peace. This is where you can get into speed limits and even anything dealing with criminal penalties. You can regulate hours of business. You can depending, and there's certain restrictions on that. You can even regulate recreational activities. You also, so that's your police powers. You've got public health powers, and we've seen a lot of that go on, especially the last few years. That can also be broad. You're talking about sanitation, animal regulations on even how you're getting rid of tick populations within your county. Business development is also under your public health authorities on zoning, weights and measures, protecting the public in that way. Even fraud, I would argue that's under your that could be under public health or your police powers. And you can do a lot in all of these fields with your local powers. And much of this is constitutionally protected. And then we'll talk about a little bit the state, how the state can restrict that a little bit. Next. In the state constitution, eminent domain, it's rarely used, but when you need to, you have that ability. The power to apportion costs of government services. This is so well, and we'll get into taxing in a little bit. That is we have that ability. The state can restrict that and does, and also grants us the ability to tax. We cannot tax unilaterally. We need state permission to do so. So as you probably all know, you've got a sales tax that helps with county functions. That funds much of what we do on a county level. That is under state law. We are granted up to 3 cents per dollar, 3%, as a baseline to every county to help us do our functions. Anything over that, we need to go to the state and ask for another penny. So many of your counties that are probably listening, you actually have 4% or 4 cents per dollar. Even some have 4.5. If you got over 3, that was because you had to go to the state. You can't just pass that by local law. You got to go to the state and ask for that help and permission to do that. Next. We talked a little bit about this, so we can move on past that. So let's go stay here. So now we have this protection to a point, but then there's even constitutional restrictions. we don't have any say over school systems, right? That's, even though that can be a school system within our county, that is both their own body as well as the state oversees much the public school system. New York City is an exception to that. So in New York City on this call, they oversee their public school system. But for the rest of us, that is not something by local law that we can interfere with. Matters relating to the administration of courts. This is a state and OCA function. We used to have, we even have things called, right, you've got a county court judge. That is not a county court judge. That is a state judge these days, and that's been changed. And that the administration of the courts is beyond the scope of our power, and that's even by constitutional, unless state authority on that. Next. So the authority and few restrictions are done with through the Constitution, but then you've got state statutes, and we'll talk a little bit. But municipal home rule is the main one, and that's going to talk about some things that you can and can't do within that section, and then it's also that's really where we're going to end with the second half of this. We'll get to in a moment. It's going to talk about exactly how you're going to, it gives you the procedural steps of how you're going to pass your local laws when you do. It's going to be a municipal home rule law. Next. There's also the statute of local governments. These are the seven. They just list out the 7 powers and then some that you're given. Again, it kind of gets into things we talked about before, what you can and can't do. This is under something called the statute of local governments. State law, so what gets interesting about this is, unlike the Constitution, the state could change these if they feel the need to unilaterally, as opposed to the Constitution needs to go to the people to change, and that's rare to ever change the Constitution. State statute could get changed tomorrow if the state wishes. Next. So here we're talking about penalties and local property taxes. A lot of this is within the statute of local governments and general municipal home rule law. Next. Talked about this as well. Again, this is where you're going to find what and how you can pass local laws further defined in municipal home rule law. Next. And again, the takeaway you want to know is authority, Constitution, and then restrictions thereof or within state law. Next. Okay, let's talk about local laws. This is where we're going to get to. Back one, perfect. This is really how, when you look on on the paper, this is what's going to be in front of you on exactly how your local law reads. So first, you're gonna, if you're even backing up a little bit, you're gonna look at and say, hey, there's an issue in our county. We need to address this, and we're going to need to do so by local law. So the first part is even brainstorming as a legislator, looking around, how can we help when we're going to talk about this example. So let's actually talk about this example now to show what some of the power and your policing power and public health powers. 2010, everyone's getting cell phones and driving, and it's clear that the accidents are occurring at a higher level, right? Yet there was nothing in state law to stop texting while driving. Our sheriffs were noticing this. They're reporting it to our county legislators, and the counties were looking around and saying, we need to do something about this, right? So this was passed on a local law level first of a restriction on it would be a violation for driving while texting. Counties were the first to pass in New York laws restricting this. So you identify the issue and how we're going to get there. But now you need to put a pen to paper. And how do you do that? And you need all 4 of these things, and they need to be done properly, or else all that work you went through, the hearing that we'll talk about later, the vote, It can all be void. So getting this part right is important. The title, you need to have, it's one sentence what it is. So you're flat out saying, Suffolk County's local law to curb texting while driving, right? Like that is your title, and it needs to spell out what's there. Now, what's important, and this is different than arguably state law, certainly federal law. Counties can only have one issue at a time with your local laws. So this can't be the texting while driving, curbing texting while driving local law, and then it'd be about farming restrictions later on. It's a one issue, one title, clean. This is what it is. Moving on. You've got then something called the Enacting Clause. This is important to let everyone know who is passing this and when this is being passed. So this is, for example, so it's as simple as saying it would not even spell out, this is the Enacting Clause. This is being enacted by the Schenectady County Legislature. So and that's usually right up front as well. You're letting the people know, like we said, this is a law. It's going to be within the boundaries of that county, and we know that it was which body. It was the Schenectady County Legislature that passed this. Third, the body. So this is now you're getting into everything that this law says, the whereas clauses. Here's where you're going to put in your intent and purpose, right? So you're going to say that we did a study on our sheriff has done a safety study and found in Suffolk County that car accidents have gone up by 20%, and we have reason to believe that this is due to cell phone activity, etc. Right? So that's the beginning of within the body. You're explaining the intent thereof. But then you're going to go into everything else. You're going to say, not just the intent, that here's what we're going to do, here's how we're going to restrict it, and here's the penalty by which, if one is violating this local law, and not all your local laws have to have penalties, but many do. And your penalties, this is something I think you really want to take away. You're pretty liberal on what you can do with civil penalties, as long as it's within reason. And what does that mean? It depends on the subject, but you can fine relatively heavily if that is reasonable to curb the activity. You can also do criminal penalties when appropriate. The difference between your ability on a local level for criminal penalties as opposed to the states are you are restricted to 1 year at most for the penalty. It can be a civil and criminal fine potentially with it, but no, it's the way that's it's sort of easy to remember, and I think this is actually the logic behind why the state has restricted us to only 1 year. Is your jails, your county jails, where one would go if they violate that, only that they're 1 year or less for any kind of prison sentence or a jailing sentence. Anything over that, one would go to state prison. So you in essence can't send with your penalties any resident or anyone violating a local county law to state prison. It would only be within the jail. Then finally, your effective date. Your effective date is again very important to have. You're letting the residents know: is this effective immediately? Is this effective in 6 months? Or does this sunset at a certain date? And needing all 4 of those to properly get your local law through. Next. So these steps and we'll go back 1 second. So all of these are also needed. So that was how the local is going to look. All these steps are needed, and there are ways that you need to do each one properly. Again, penalty can be that you go through all of this and it's void or voidable. Next, the first is going to be the introduction of the local law. Next, Jeanette. I think we'll talk. So it's been drafted, the local law. Now, many of you here have county boards, some have county legislators. One member of the legislative body is going to, maybe through the help of his county attorney or her county attorney, draft this local law, and the rest of that body needs to get an exact copy of what is this law. You can't bring this to the floor the day of and vote. This has to be given 7 days prior to any vote. It's got to be mailed or hard copy given to each of the members of the body. Can't be changed within those 7 days. It's got to be, this is what the local law says and does, giving each legislator some time to figure out questions they might have, proposed amendments. Do they like this? Do they not like this? If you're going to do it by mail, it's got to be 10 calendar days. I think within this also, Sundays don't count either. So you got to anticipate that. But this is the introduction part and getting that actual local law to all members, just even in fairness to them, that is required by law. Next. A public hearing. So that's so one piece is you have to let your legislators know, right? The other piece is you gotta let the public know, and they need to. So you have to have a hearing on this before you pass this. And they need to know at least 5 days prior to the hearing date. You can, by local law, and you'll say some of your counties will say, wait a minute, we do it in 3 days. You can, by local law, change that to 3 days. Under you're granted that power. So some of you might have 3 days that you do public hearing. And you know, this is you're putting this in the newspaper. You're letting the public know on your website, and you have to put that local law out there for them, and to understand what is being discussed, and so that they have a proper time to show. I know Shauna next is going to talk about too. This is where it's sort of hands off in a bit, that you've got to provide for, with this hearing, proper space for this function to have with this public hearing. Meaning, it's going to be a packed house. You got to do it in a place that can handle that. It doesn't mean you need to knock down the walls or anything of your meeting space, but if you can't have it in a room that can only seat 3 or 4 people either. It's all dependent on the area and what you're doing, and I won't step on what Sean's going to talk about, but this hearing process has to happen, and before anything is passed, and at least 5 days prior, the public notice must be given. Next. So at this as well, that you're gonna have to have consideration by the legislative body, discussion, open discussion, goods, bads, any defects or things that need to be changed and addressed. So prior to this getting voted up or down, this is where that happens. If the body agrees, even like the person presenting the local law, you know what, I didn't think of that, good point, we're going to change this, we're going to add a whereas clause in here, that starts the whole clock over again. So you can't change this on the fly, especially substantive changes, and then pass it. It's got to be, if you're going to make amendments, now that changes the whole thing. Everyone needs to sit on that again and go through that whole 7-day process again, and then pass it. Next. The vote. So this is obviously a huge step. At the end of the hearing, the local law can be voted on. So it stays, no amendments made, and the vast majority of your local laws are passed just by majority vote of the legislative body. Your exceptions to that is those counties with county executives, they get the chance to either approve or veto the local law. There's also certain things, certain local laws that you can pass that may require a referendum. So let's say, or even a super majority vote. Super rare, except for overriding your tax cap. That's one that counties, especially in harsher fiscal times, the super majority, you're going to need 2/3 of your body to vote to override the tax cap. That's under state law. Everything else is majority. You want, if you will, and then there's referendums. We'll talk about that in a minute. Let's say you're trying to create or take away a power of a local elected official. You can't just do that by majority vote. That needs to be a vote and then a referendum of the people. You need to, if you're going to make a massive change like that, that impacts the power of, let's say, an elected official, it's got to go out to the people and they have to also approve by referendum. Next. Then you have to file, because let's say you pass it, great, or your county executive approves, great. It's still not on the books yet and still not effective yet. You have to send we're calling a true copy of the local law, and it says full text must be published in the official newspaper. I think the law changed recently that you can do a overall summary. I don't think it has to be word by word, but let me double check that. I do think that changed recently. But more important, well, I guess that was just as important, but also as important, you need to file this, as we talked about before, to the Department of State, the Secretary of State, and once they receive that filing, now it's adopted. And if it's effective immediately, what effective immediately means is upon their filing, the Department of State, and then you should see that up on that list that we talked about earlier. Next. I will get really fast through this, but so there's restrictions. We talked about referendums before. Let's skip that. Preemption. You need to know what preemption is. Preemption ultimately means that you weren't allowed to pass this, or someone else passed something already and you can't get in that field. What does that mean? You can't pass a local law that is conflicting with the federal constitution, with current good valid state law. You're preempted. You're preempted from each other with local governments on many things. So let's say, that we talked about, the county is restricted to pass that local law within their boundaries. A town passes a local law that they're permitted to pass a local law on the similar subject within their boundaries. That town preempts the county, not in the whole county, but in that town. So if a town is, again, without restrictions, as a valid local law, and that speaks for that town, you can pass your county, but it's going to be the local laws can preempt each other within their own boundaries. We talk about majority vote and supermajority and referendum when that happens. There's one other place with, and I think we'll go next, Jen. I think we'll talk about preemption a little bit more, and then I'll be close to done. Let's get by referendum, but that it's under, how it's done is under section 23 and 24 municipal home rule law, and when it happens. So state preemption. This is a good time to, and I know I'm running over a little bit, so I'm going to be real quick. You cannot pass a law that the state has already clearly spoken on, right? Now that can get confusing, and what does that mean? The courts can find if this is a matter of statewide importance, even if the state didn't speak on it, a court can say, you know what, you shouldn't have gone in that field. That is a statewide issue. It'd be too confusing to have one county doing one thing in this field, another county doing another, and it's no good. I can think of I'll give you a quick example and then move it over to Shoshana. About 10-15 years ago, there was a county that passed, there's a state law that requires that those that are registered sex offenders cannot reside within 500 feet of a school. And that's under state law, spoken for. We certainly can't preempt anything that deals with that. One county saw that and said, okay, we're not actually preempting. The intent of this law is to not let anyone registered to live within 500 feet of a school. We're not, they didn't believe they were conflicting with that law by passing something that said, well, in our county, 1,000 feet, a registered sex offender can't live within a school, and we're going to redefine what a school is. A school is going to be any place where children gather, right? So that's, and so arguably, does that conflict with state law? At least that the county that passed that thought no. This actually now started to go to their counties, and there was up to like 15 or 20 counties that ended up passing this local law before it got challenged. State looks at that and looked at that, and they said, you know what, even if the state didn't specifically say 500 flat, no change on that, this is something where the state occupies the field. It's too important of a statewide issue. We are striking this down. You are preempted from passing a local law like this. All the county local laws that were like that were found void or voidable. Next. Talked about a lot of this already. Attempting to legalize something state already prohibits. You can't do that. Next. Again, covered a lot of this already. We can go next. Let's try to get to Shoshana. Sorry, state occupied field, perfect. Already talked about this. Next. My biggest advice too, your county attorney works for you. Please talk to your county attorney when you got questions on any of this, especially even when drafting, when you're early on this, of saying like, wait a minute, does this violate? I feel like we can't do this, and does this violate any provision of the federal or state constitution? All that said, I know I talked a lot about restrictions and what we can't do. You've got a tremendous amount of power, so definitely be proactive with this stuff and talk to your county attorney about it. I'll leave it with a couple examples. Again, I know I talked about the cell phone, texting while driving, and it was counties that passed that, and it spread county by county, and finally the state said we have to do something about this, and they finally adopted something statewide law. That kind of thing happens all the time. A good example of like, wow, I can't believe we have this kind of power, but it holds up, and we do. Under public health, we have counties that passed, we banned styrofoam cups within counties, and you have powerhouses like McDonald's and Dunkin' Donuts that use styrofoam cups, and counties said, you know what, this is hurting our environment, this is hurting our public health, we're not allowing styrofoam cups within our county. That held up. That is and I'm not agree or disagree with the policy. It's amazing the power. And so now that they saw this was an issue. They had a public debate about it. They pass it, and now that it's got to be recyclable cardboard, right? At these venues within that county, and it's really. I just want you to think about that, because of just your ability to make change is pretty amazing. I hope you do it and help your residents well. But we're here to help with any guidance on any of this and any examples. But that's it from my end, and then I'll help with questions after. I will turn this over to Shoshana. As Jeanette mentioned, the Executive Director on the Committee on Open Government. I'll say, I know I've talked a lot. I want to say this about the Committee on Open Government. Of all the state agencies, they get back to me the fastest, and I think to all our county members, and the best. And I can't speak highly, more highly about an agency in the state on getting good quality, quick information to counties when they need it. So thank you for being here, and thanks for all that you do.
Oh, well, thank you so much for having me. And hello, everyone. My name is Shoshana Bewley, and I am the Executive Director of the Committee on Open Government. And we are here to answer your questions for sure. So we'll speed through some of this information. The information that is contained in these slides is available. Again, it will be available on the website, as Jeanette mentioned earlier. And we do more specific trainings on open meetings, and FOIL and personal privacy protection routinely, virtually. We have signups on our website. So you can always tap into that, call us anytime. Next. This is where you can reach us. The number is our general number. The website is our website, and my email is there. We also have a shared email that everyone answers immediately, and that's coog@dos.ny.gov, and that'll be at the end of the slide deck as well. Next. This presentation now is about the open meetings law, specifically as it has been amended 5 times in the last 5 months. So I thought as newly electeds or appointeds, you might be interested in knowing what the current state of the law is, because it has been in flux as a result, I think, of the changes that have come about as we've been dealing with having meetings remotely during this time of pandemic and public health emergency. Next. So these are the times that it's been amended in the last 5 months. We sort of started with Chapter 417 of the laws of 2021. This was essentially a codification of a prior executive order of the last gubernatorial administration that permitted public bodies, such as county boards and county legislatures, and to meet remotely as long as they were doing certain things like recording the meeting and allowing people to listen in as the meeting was happening, using a platform like this or like Zoom or WebEx. Then we had Chapter 481 that changed the law relating to records that are scheduled to be discussed at a meeting. Then along came Chapter 587, which related to the posting of meeting minutes, which before that time were not required to be posted. They were required to be taken, but not to be posted. Now they're required to be posted. Chapter 676 of the laws of 2021 redefined public body, and we'll talk a little bit about that quickly. And then very recently, Chapter 1 of the laws of 2022 amended and extend Chapter 417, which permitted remote meetings, and made it so that Chapter 417 will now expire when the public health emergency expires. Next. So public bodies, for a long time, the definition of a public body didn't change. Now it is changed. This is just a definition. If we go to the next, I'll break it down for you. A public body is a body containing 2 or more people that operates by a quorum, that has the authority to act collectively, and it also includes its committees and subcommittees. The new bit as of December 2021, that those entities that are created to perform a, quote, necessary function in the decision-making process that is not merely advisory is also a public body. That was clarified. Next. So rolling back, the intent of the open meetings law is that public should be fully aware of and able to observe the performance of public officials. So that's the fundament. That's the essential predicate. They have the right to attend and listen to our deliberations and decisions that go into the making of our public policy. But next, recently, because of the public health disaster, we have had a series of permissive extensions to the authority of a public body to meet without permitting the public to be physically present. So again, recently the governor signed an extender on this that makes it basically coextensive with her executive order, that it keeps getting extended by 30 days every month. So what we have now is the authority to meet and take actions authorized by law without permitting in-public, in-person access to meetings by conference call or similar service, so such as a meeting we're having right now, provided that the public has the ability to listen or view, and that meetings are recorded and later transcribed. So again, this is permissive. It allows for remote meetings, but does not require remote meetings. Let's move next. So this is what a meeting is. The only thing I'll say about this is that a meeting and a hearing are different. So you may have noticed when we talked about the definition of a meeting, or a public body rather, it was where a quorum is required. A meeting is where not only is a quorum required, but a quorum is present. So a hearing may operate where you have members of your public body there, but not all of the members. Not a quorum is not required to be there. And if it isn't there, for example, you may not be having a meeting and the open meetings law requirements may not apply. Certainly all of the public hearing requirements will. Next. So again, bearing in mind the difference between a meeting and a hearing, if you have a quorum of your public body present and you are a public body as defined by law, you can't take an action unless you're having a meeting. Or I suppose a hearing if your public body has hearings. So you may not have a meeting by email. You may not vote on something by email. You may certainly discuss it, however. Next. This is the definition of quorum. Most of us know what a quorum is, but it derives from the general construction law in New York, and it's not less than a majority of the whole number of people who are members of the public body, assuming there are no vacancies. Next. So gathering a quorum for an in-person meeting is a long-standing issue for folks. It's sometimes hard to get everyone to agree to meet all at once. Since Chapter 417 has been in effect, members of a public body who participate remotely count toward a quorum and can participate. It's much easier to get a quorum now. This also includes executive sessions, which we'll talk about later. Next. So video conferencing has always been permitted by the for many years has been permitted by the Open Meetings Law. But prior to Chapter 417 and the executive order that preceded it, if you are a member of a public body and you are participating in the meeting by video conference, your location must have been open to the public. So I'll give you the example is we use my own public body, the Committee on Open Government. When we meet using video conferencing, and we have locations in Albany, Buffalo, and New York City. And those 3 locations are open to the public, and we have members of our body participating live from there using video conference to connect the 3 public locations. During Chapter 417, and while it is valid, we may meet in many other locations, such as living rooms, and not open those locations to the public. Next. If you use video conferencing, you must permit the members of the public to listen in or watch, but you need not currently allow the public to participate or attend at any location where a member of the public body is participating. Next. These are requirements that Patrick touched on this briefly. When you have a meeting and you intend to have the public be able to come to the meeting and be present, whether you allow them to say anything or just watch, you should pick a location that can accommodate the number of people that you intend to, or that you believe will show up. You got to also note that the Open Meetings Law does impose a requirement that you make reasonable efforts to ensure that the facility is barrier-free. That doesn't mean that you have to conduct an assessment according to the ADA, but it does mean is that you have to make all reasonable efforts to ensure that someone who doesn't have the same abilities as others to access the location can do so. Next. So again, as a sort of a review and a summary, are you having a meeting? Do you have a quorum? If you don't, you can stop asking. Are you discussing public business? If you're not, you have sort of a sub-series of questions, but generally you're not having a meeting. But if you are, you're having a meeting regardless of whether you intend to do anything like vote, or whether you call it a work session, or a get-together to discuss something that you're later going to discuss at another meeting. These are all meetings. Next. So again, I've seen many questions come in where members of the public are questioning whether their public body in their location was actually having a meeting that they didn't let them into, and they called it an agenda session or a workshop. Definitely, these were meetings, regardless of the intention to, take public comment or formally vote on something. Next. So here's what's not a meeting. A site visit where members get together to go and see, say, somebody's trying to get a variance on whether a use of a field that these people are all in here on this picture is to be used for a different zoning application than it currently is used for. You can visit that site if you don't make discussions, if you don't have a back and forth conversation. That site visit isn't a meeting. Retreats are not meetings. Attendance at a committee meeting where you are not a member of the committee and you are not participating in the committee is not a meeting. So if you have a committee that is meeting a different committee of a different body or anything, you don't make it a meeting of your body by you attending. And social get-togethers. Next. So physical presence or video conference makes it a meeting. Teleconferencing is also permitted while Chapter 417 is in effect. Can't vote by email, but you can share by email. Next. Notice. Now, a lot of different notice requirements will probably apply to things that you as newly electeds and appointeds will do. The notice requirement for the open meetings law is the least onerous of the notice requirements that you'll probably run into. Notice requirements for hearings are much more rigorous. They require publication in the media, sort of more of a legal notice requirement. This notice requirement requires you to post the time and place or instructions for virtual attendance prior to the meeting. And the statutory requirements generally are using your best efforts at least 24 hours in advance for this kind of meeting, an emergency, or 72 hours in advance of a meeting that you have at least a week of lead time on. You need to send it to the media, like you can issue a press release, and you need to have the designated location, and you should post it on your website. Next. Yeah, here are the main requirements that we just discussed. Next. Minutes. Many of the meetings that you are at or attend, you may not, you may have someone who's designated to take minutes, and so that would be these instructions would be for that person. But generally speaking, under the open meetings law, minutes should include any motion, proposal, or resolution, and a vote, including who voted for what. If it's unanimous, you can say that, but if there were abstentions, you should note that. Executive sessions minutes are needed only if actions are taken within the session. New law must be posted, the minutes must now be posted on the website if you operate one within 2 weeks of an open session or 1 week of an executive session. It doesn't matter if your minutes are not yet approved by the next meeting of the body where you would necessarily approve the minutes. You can indicate that they are in draft. You may post now a transcript or recording of the meeting in lieu of minutes, which is a new item. You don't need to take a minute if you have a transcript of the meeting. Controversial new law, but it is in fact available to you. If you don't want to take a minute, you can just post a transcript. Next. Any meeting is shall be open to being photographed. So that means anyone can do it. You can do it or others can do it. You're not obligated to record it, but you must record it if you're taking advantage of a remote meeting pursuant to the new Chapter 417. And you may establish reasonable rules to limit disruption. We have some model rules on our website. This means that if you have someone who, a member of the news media who wants to record your thing and has lights shining and, camera cables everywhere, you can, in theory, you can make a reasonable rule to limit the impact of that kind of a disruption, certainly volume restrictions and things like that if there are alternate people in there recording your proceedings. Next. So an executive session. An executive session is part of an open meeting and is not separate from an open meeting. It cannot be scheduled to happen on a different time or at a different location than an open meeting. It in fact the motion must be made in the open session and it should be specific. Next. So I'm not going to go through, these are the reasons. It's in the statute and you can absolutely look at it at your convenience. Next. Next slide. So the one sort of bugaboo that the courts have and I guess the committee has long had is, this is one of the reasons why you can go into executive session to discuss the medical, financial, credit, or employment history of a particular person or corporation, or matters leading to the appointment of a particular person or corporation. So you can't go into an executive session to discuss personnel. You kind of have to identify what of all of these things it specifically is in order to successfully have an executive session. Next. Public participation. A couple things. Meetings and hearings will be very different on this topic, but for a meeting rather, which is sort of within my statutory remit, public participation is not required. You do not need to enable members of your locality to come and comment on things if you do not want to. You may establish rules for that, like 3 minutes, must sign up. You have to implement those rules fairly and consistently. Can't say people who are opposed to this proposal can't speak, but people who are in favor of this proposal can speak. That wouldn't be fair. And hearings, again, not the same as meetings. Many hearings have rules and requirements that require people to be permitted to testify or participate. Next. This item may impact you. Records scheduled to be discussed. So any proposed resolution, law, rule, regulation, policy, or an amendment to any of those, or any records or portions thereof that are otherwise public under the Freedom of Information Law, now, as of October 19th of 2021, shall be made available upon request within 24 hours of the meeting. Now, since 2012, records scheduled to be discussed were always supposed to be available prior to or at the meeting. What's new as of October 19th is that there's sort of a 24-hour time limit now. So if what you're discussing, and it sounds like from what Patrick said, you will be discussing at times things that are definitely available more than 24 hours before, such as drafts of local laws and things. Those have to be made available if you use a website at least 24 hours prior to the meeting, so that members of the public have an opportunity, at least 24 hours of an opportunity, to review those materials that are scheduled to be discussed. And you may, but are not required to spend money to implement this section. In other words, create a better website, for example, or hire someone to organize your public documents. Next. So there are exemptions to the open meetings law. If you are enjoying one of the exemptions, you are not having a meeting, and the open meetings law doesn't apply. Judicial or quasi-judicial proceedings, deliberations of political committees or caucuses, and any matter made confidential by federal or state law. Specifically here, if your attorney is having a meeting with your body to advise you about something, that is not a meeting for purposes of the open meetings law. Next. Enforcement of all of these items is through a lawsuit, expensive, difficult, rarely leveraged in the open meetings law context. Very light sanctions, so not very hard to, unfortunately, not very hard to get away with violating the open meetings law, but not a very good look because it's always reported in the paper and you always get a lot of grief. Next. Good questions. Obviously, I'm hoping that any questions to my very fast presentation, and I'm really sorry about that, have come in through the medium of this platform, and we can answer them whenever you now, or if we end up not having time, anyone can call me at any time at that number or contact us at that address, and we will respond. And as Patrick said, it is our definite wish and hope that we respond quickly, accurately, with needed information and follow up if we don't understand your question, for sure. So thank you so much for having me.
Thank you, Shoshana. I do have a couple of questions that have come in that are definitely for you.
Okay.
The first one is, why did the New York State Legislature move to allow a transcript or recording instead of minutes? Watching a 2-hour meeting online to find out what was passed at a meeting is a barrier to public participation. Who are good contacts for reviewing this new legislation and its impacts?
Oh, well, that's a loaded question. I don't know who was the prime mover for allowing this. I think that it was potentially expediency because the transcription requirement didn't exist until the remote meetings permission came into effect. At that point, people started to use these programs that allowed that right now, in fact, probably this platform will transcribe our question and answers, our presentations. It won't be perfect, but it will try to record what we've said, and then you can automatically generate a transcript. I believe that the motivation was purely expediency here. I think that, I believe that, the Committee on Open Government, when we issued our most recent annual report, which was on December 15th of 2021, we did identify We certainly were in favor of the posting of meeting minutes because the requirement to write minutes has long existed, and the requirement to have them and to make them available to people has long existed. So posting them, we didn't feel added an additional burden. I don't know if we had an opportunity, because this law postdates the report, whether we had an opportunity to comment or to provide sort of considered thought on the idea of substituting a transcription. My personal opinion, for what it's worth, is that I don't think it's a substitute for minutes. I believe minutes are very helpful and can be very helpful, but I do think that it was just an expediency question. And I guess my advice would be to contact your representative and articulate your dissatisfaction with that, and see if there can be, potentially an amendment or an adjustment to that to continue to require those minutes be created and posted.
Thank you. A couple more for you, Shoshana. So no items or topics not on the agenda for a meeting can be discussed. Is that correct?
No, actually, there's no requirement that you make an agenda or use one. There's no requirement that you disclose to anyone what you intend to talk about before you talk about it. With the exception of, if you're planning to talk about a document, as we discussed earlier, you need to make that available. So yeah, surprises come up all the time on agendas. And in fact, if there's something that you did not intend to discuss, but that comes up and you end up intending to discuss it, and it is a document, for example, there's no penalty for not having provided that 24 hours in advance if you did not intend to discuss it at least 24 hours in advance. These things happen. So my suggestion is that you do your best to try to figure out what you're going to speak to, and we obviously should operate in good faith and make available everything that we definitely intend to discuss, but things come up, and that does not prohibit you at all from having those discussions and discussing those materials that you did not necessarily yet intend to discuss, but have come up and feels like the time is right.
Thank you so much, Shoshana, from the Committee on Open Government, and thank you, Pat Cummings from NYSAC. That concludes our program for today. Thanks so much for joining the webinar, and we'd like to remind everyone to join our final upcoming program next Thursday, February 3rd, on the role of clerks of legislative boards and an overview of NYSAC's programs and services available to our members. Again, thank you to Patrick Cummings of NYSAC and Shoshana Bulle of the New York State Committee on Open Government for sharing their expertise today. I'd also like to thank the generosity of NYSAC's Excelsior sponsors for underwriting this orientation series. That concludes the webinar. Thank you, and have a healthy and productive week.